With NCAI. I'd like to thank you for joining us in this webinar. Currently, there's just a little bit of background. All the phone lines are should be muted until the end of the presentation when we're going to take questions. Then you can raise your hand. You have the opportunity to ask questions during the webinar, and I'd actually like to encourage you to ask questions today. If you write in questions, we get to gather them all up. I actually think it'll be really interesting to see what questions the participants may have about this new Supreme Court decision. Where there's going to be a question and answer session at the end. When that comes along, there's a raise your hand button on the right. You can raise your hand, and then your line will be unmuted, and you'll be able to talk. So now I guess I thought I'd turn to the topic. Today's discussion is about the recent Supreme Court decision in Lewis versus Clarke. I think probably many of you are already familiar with the basics of the decision. I'll just say briefly that when I read it, my first thought that it's a relatively short read. It seems fairly straightforward. But then after you started thinking about it for a minute, a lot of questions came up. I started talking to other attorneys around Indian country, and there were a number of different perspectives on what the decision means. That's often the case with a new Supreme Court decision, that it takes a little while to shake it out and figure out what the decision is going to portend. So we thought we'd put this webinar together to hear some different perspectives and start figuring out in a discussion. There may be some actions that tribes will need to take to protect themselves, but the tribes also have many strong legal arguments left. This is just a beginning discussion of a new Supreme Court decision, so obviously there's a spotlight on this case, but it fits into a body of case law that protects tribal sovereignty immunity. We have a lot of people joining us today. I think right now we've got about 138 people on the webinar, so it's quite a few, and maybe getting bigger. After we finish with the Lewis versus Clarke discussion, we're going to turn to another topic, which is the large number of federal judicial vacancies and vacant U.S. attorney seats all across the country. So there's kind of two parts to this webinar, and we'll hope you stick around for both of them. With that, Richard Guest, have you been able to join us? I wasn't sure if Richard, he may be a little bit late in joining us. Julian, why don't we go on to the next slide? And there's just a moment here, and I'm going to introduce the attorneys for the Mohegan tribe. I'm going to start with Mitchell Reich with Hogan Lovells, and then we'll talk to three of the attorneys who represent Mohegan. So Mitchell, I'll turn it over to you.
Great, thanks. I'm Mitchell Reich. I'm attorney for Hogan Lovells and one of the authors of the tribe's brief in the Supreme Court. So I thought I'd talk briefly about what the decision held and what questions are left open at this point. So as you're probably aware, the court, this was a loss. The court issued two holdings. One is that a suit against a tribal employee in his personal capacity seeking monetary relief out of his own pocket is not barred by tribal sovereign immunity. And second, that the tribe's agreement to indemnify the officer doesn't change that. And that's really the extent of the decision. It's a very self-consciously narrow decision in a couple ways. One is that it emphasizes multiple times in the opening two paragraphs, and then later in the body of the decision, that it's only deciding the question of whether sovereign immunity blocks that type of suit. And actually, the court included some helpful language in the body of the opinion about why it decided sovereign immunity didn't block it. One was that it did express concern about using suits against officers to circumvent the tribe's sovereign immunity, and recognized that wasn't the case here, but could be the case in other contexts where someone nominally sues an officer of a tribe, but is in fact really suing the tribe itself. Second, the court emphasized that it was giving tribes what it perceived as the same sovereign immunity as the federal government and states receive, and wasn't treating them any differently, which could be helpful in other contexts. And finally, in footnote 2, the tribe left open what we thought was one of the strongest arguments for preventing this type of suit, which is that although the tribe's sovereign immunity might not block it, the officer himself might have an official immunity from suit. And the court did not address that issue at all, and that remains open to lower courts after this. So I think that at this point there are really three paths forward that we see, and there could be more, but at least three for immunity in this context. I'll just summarize them briefly. One is we think there would still be an available arguments based on comity, that where a tribe grants its officers immunity that is no broader than the immunity that a state grants to its own officials. So, for example, in this case, the Mohegan tribe granted absolute immunity to its employees from tort suit. The state of Connecticut does the same thing for its employees. There's a strong argument under both state law and federal law that the state is obligated to grant comity to the tribe's own immunity rules, and that argument remains open. Second, under existing common law, federal common law doctrines of official immunity, many tribal employees will be personally immune from suits in this context. The current federal common law that most courts recognize grants immunity for any discretionary acts that an officer undertakes, and the federal government in its brief in the Supreme Court endorsed that version of official immunity. So that probably would not have protected an employee who's just engaged in purely non-discretionary acts, and many courts find that something like driving is not one, although in some cases it might be, but that would protect many employees. And finally, in our Supreme Court brief, we emphasize that the common law rule should actually be broader than that, and that in light of Congress's enactment of the Westfall Act, which grants immunity even for non-discretionary acts, common law official immunity should actually extend to all acts an employee undertakes in the course of his duties, whether discretionary or not. And while that may be a difficult argument to win on in the lower courts, in the Supreme Court, we think that's still a very viable argument, and it's worth teeing up for future cases. So I think I'll leave it there, and can get into more detail in the Q&A if that's helpful.
Thanks so much, Mitchell. That was a really helpful overview. I actually appreciate that a lot. I want your notes. Next, we're going to introduce Helga Woods from the Mohegan tribe.
Thank you, John, and thank you, Mitchell, also for that overview. I'd like to recognize and thank Linda Akampora, who's sitting here with me. She's senior legal counsel for the Mohegan tribe, and she did a tremendous amount of work on this project. And I also want to thank Richard Guest and NARF, John and NCAI, all of the tribes and the law firms supporting the Mohegan tribe in this case, and all of the governmental bodies and representatives that filed briefs in support of us. They did an outstanding job, and the Supreme Court Project Group was terrific to work with on this matter. The Mohegan legal team is obviously disappointed that the Supreme Court did not concur with the Connecticut Supreme Court in recognizing the Mohegan tribe as the real party in interest in this case. We believe that we had sufficient evidence of tribal law and tribal agreements, namely the compact, to establish that the tribe is the real party in interest in this case, so that sovereign immunity should have prevailed. The Mohegan tribe established the Gaming Disputes Court over 20 years ago to hear all matters related to the gaming authority, and adopted a comprehensive code of laws, including a tort ordinance, to allow for appropriate remedies and forum for parties similarly situated to the Lewises in this case. And the Connecticut courts have long recognized the Gaming Disputes Court as the appropriate venue for tort action and other actions involving the tribal gaming authority. As Mitchell noted, the little bit of good news in this ruling is that it's limited to sovereign immunity. The Supreme Court notes that there's other immunity defenses distinct from sovereign immunity that may be raised on remand. As Mitchell noted, official immunity is one that was specifically noted, even though we argue that it's got a close relationship to sovereign immunity and should have been decided by the court. The court determined that the defense was not properly before it because it was not considered by the Connecticut court. We also note that the Supreme Court noted itself that the decision relates to torts committed by a tribal employee operating a vehicle within the scope of an employment but on state lands. We don't believe that the ruling would affect torts committed by tribal employees on the Mohegan Reservation, which we believe would continue to be in the Gaming Disputes Court under Mohegan law. Someone asked yesterday, where do we go? Where does Mohegan go from here? As to this case, we intend to defend the matter with other available defenses and to hopefully resolve the matter. As to an overall view, we are examining Mohegan tribal laws to determine whether and to what extent to recommend to the Tribal Council appropriate revisions to tighten the recognition of tribal courts and tribal remedies as the first and appropriate remedy for all tort actions. We also intend to consult with our insurance carriers and counsel to determine other appropriate courses, and we would welcome further collaboration with other tribal legal counsel on additional solutions to assure recognition of tribal law and tribal courts in these circumstances. Thank you, John.
Thanks so much, Helga. That was also great. Is Dan Krish, are you there?
I am.
Thanks so much for joining us.
You're welcome. I don't have much at all to add to what Mitchell and Helga had to say. I think they gave a comprehensive and thoughtful presentation. The only thing I'll add, because I understand that a couple questions or discussion of it came up yesterday on the pre-call, I thought that the Supreme Court decision sort of took a blinkered view about the realities of whether or not it's a choice for the tribe's resources and treasury to be at stake in this lawsuit, leaving aside the statute that requires us to indemnify them. Connecticut law, and I think I would be shocked if the law is different in other states, doesn't allow cars on the road unless they have liability insurance, and any authorized user of the vehicle, by definition, covered when he uses the vehicle on the roads in Connecticut. And so, it's hard for me to see the logic in saying that the tribe's not the real party in interest in these circumstances. But as Helga said, we have a strategy going forward, and certainly I learned a lot and really enjoyed working with all of you on the case. Thanks.
Thanks, Dan. This is Richard Guest at NARF. Apologize, we were on mute at the introduction stage, and we really do appreciate all the attorneys for Mohegan Tribe taking time out. And just to provide a little context for those on the call, Mitchell was co-counsel with Neil Ketchell, who argued the case. Neil, unfortunately, could not join the call, so Mitch stepped in and provided that excellent overview of the opinion. And Helga is in-house with Mohegan Tribe, part of the legal team there, providing that expertise to the tribe. And Dan Krish is the attorney within the state of Connecticut that argued for the Connecticut Supreme Court and was successful in his argument there. So we really appreciate them coming on the call and providing that their perspective on where things stand for Mohegan. John, I think we're ready to move to the next set of presenters, and that would be representatives from the tribal insurers.
And there's your slide. Yeah, I think. So, hi, Dina.
I'm sorry. Did you want to introduce me, or should I just go ahead?
Well, I would just want to let folks know that you were on the amicus work group call, that you expressed a very specific interest on behalf of Hudson Insurance and offered some of the data that the amicus parties reviewed as part of the strategy and putting information in front of the court. So for that, we really thank you. And why don't you go ahead?
So just as an initial matter, and I would note that we, at least initially, don't expect things to change too much. It'll obviously take some time for this to work its way through the courts across the country. Nevertheless, I would point out that, as you all are aware, the insurance policies, they require defense and indemnity regardless of where the case is pending. So for the time being, we really don't see making any drastic changes to our product or our program. From our perspective, this case doesn't change what our obligations are under our insurance policies, regardless of whether the case is pending. We're very comfortable and familiar in litigating in state and federal courts for all kinds of lines of business. At any given time, we have tens of thousands of cases pending all over the country We have a $5 billion in reserves, and this, to the extent cases start to be filed in courts other than tribal courts, we will treat those like we do any other case under these policies. I would note, to the extent that anyone's interested, tribal claims across our entire tribal book of business, which is significant, about 5% of the total number of those cases involve allegations of negligence against an individual employee or were filed in a state court venue. We do expect, obviously, that number at some point to tick up a little bit. So we can and will manage the cases where we're filed, but we are thinking about where we'll see an uptick, and we expect that'll be in dollars paid on claims, particularly in certain venues. So depending on the case, a lot of the mundane, smaller type of cases that we handle on a routine basis, we think will continue to be handled as before. You see most of there's a lot of the slip and fall type cases that are just going to be handled, we believe will continue to be handled in tribal courts. We think that's where folks will continue to want to file those. Some of the larger cases and the more serious injuries, we do expect to see those in state or federal courts, particularly in states like California. So, what we would consider the plaintiff-friendly venues. We do expect if that happens, and it most likely will eventually, it will impact our profit-sharing programs with the tribes. That's something for those of you who participate in those profit-sharing programs, which are driven by your loss results. Your profit sharing will probably be impacted if the claim payments do go up because of the venues that we're now in. What we are working on, setting aside the actions that the tribes can take in terms of ordinances and in terms of surrounding the discussion that there's been on official immunity and what the tribes can do with that, we are working on trying to identify new or additional exposures that we think the tribes should be thinking about. I'm sure they already are. For instance, punitive damages might be something that hasn't really been an exposure for the tribes, particularly if they haven't been in state or federal courts. Regardless of whether the tribes are judgment-proof against state court awards, we expect that the tribes will view that as bad publicity to have those judgments sitting out there against them and their employees. Most carriers exclude coverage for punitive. In many states, they're not insurable. However, there are alternative markets that can be made available. Should tribes feel that that's a risk that they need to think about, at least on a short-term basis. And we can work with tribes on that, and we are looking into that. We want to continue, obviously, to protect the tribes, and we're thinking about how we can keep the plaintiffs' bar disinterested. The prospect of suing employees as least attractive as possible. One of the things we're talking about is what can we do with our policy language and our limits in that regard. We do not intend to make those changes unilaterally. It's our intent to see what the tribes want and how they want to deal with these issues. And we would make any changes to our policy in consultation with our existing clients. We take direction on issues surrounding sovereign immunity and how those defenses are raised in court from the tribes. Our policy, I believe, specifically requires that we do that. We do not anticipate changing that. We will continue to let the tribes direct how we present those issues in state and federal courts going forward. And then the final thing I would add is we do have a significant number of data on claims going back many years that we can aggregate and make available to the extent that there is information that you all might think might be helpful, and we can make our claims people available if there are questions about trends that we might be seeing within our book of business. And that's all I have.
Thanks, Dina. That's an interesting proposition you put forward for us with respect to helping us identify trends and where the cases are arising, how they're arising. I think that's going to be very helpful. So I think the project and the work group will remain in contact with you. Next, we invited Jeffrey Blackwell, who joined Ameren Risk as their general counsel. Many of you on the call, I think we're over 175 folks on the call now, are very familiar with the work of Ameren Risk. Jeffrey?
Thank you, Richard. Heshe, Chukmat All, and Mado, thank you to the American Rights Fund and National Congress of American Indians for the invite. It's a pleasure to be included in such a distinguished panel, and Ameren is honored to be involved. So this is a case we've been watching and analyzing from a couple different perspectives. As most people know, Ameren is tribally owned, and so it has a potential, it has potential interest for us in a number of places. So let me get straight to some initial thoughts and reactions, because I think the real important stuff is going to be in the questions. So first, from an insurance perspective, I agree. Nothing will change right away. This has the potential to have some significant impacts, but things won't change overnight. So it's really time to work to get ahead of the curve, and some of this has already been shared. An obvious point that hasn't changed is at Ameren, like elsewhere, we have a good faith requirement to defend tribal employees acting within the scope of their employment, reserving, of course, our rights on intentional acts. Second, this Supreme Court decision may mean more cases will be brought. I think I agree with the sort of collective here, but there's a lot here to be meted out in further litigation and further cases. But plaintiffs' attorneys are going to get strategically smart quickly, though, and it's apparent that they've been given a new tool to bring suits against tribal employees in their individual capacities and try to make those suits stick in state courts. So sort of third, here are some practical thoughts and suggestions. In the near term, just right off the bat, after having read the initial, first glance at this decision, in the near term, tribes may wish to review their codes and contracts and have nice, strong indemnification language and agreements. This is an area where I think there's some real work to be done here by tribal nations and their legal advisors, as tribes are ever growing as employers. It's important to monitor the developments and be prepared. Monitor outcomes and review needs before buying more insurance, and do that before buying more insurance. Based on both near and long-term analyzed needs, tribes may wish to look into additional or excess liability coverage to protect against excessive verdicts or settlements. But this isn't a sales pitch. My license is to practice law, and I don't have one to sell insurance. So to put a little bit of a finer point on it, tribes should do a coverage review in light of this development to make sure that their policies are in place, including the endorsements. Tribes need to be more aware of the insurance contracts they have and how they effectively work. Make sure you know how your insurers work their cases, how they approach the law and case law. Talk with your brokers and carriers. So here are a couple more basic thoughts in the aftermath of this opinion. So look, in simple terms, insurance is a contractual transfer of risk. When one speaks about risk management, there are three basic options for tribal nations. You do it yourself, you pay someone else to do it, or you buy insurance. So as always, tribes should look again at business models that mitigate or transfer the risk, looking at all the aspects of their businesses. What is better risk management? Is it better risk management to have the coach limousine service contracted out? Is it better to contract with an insurance company for them to bear that risk for a period of time? I mean, these are important decisions to be made in light of a good coverage review. So in addition, training. Training is an important point that should be a constant for tribal nations. Tribal employers should always provide good targeted training to their employees on risk management, and this case just brings that to the fore again. So, I mean, within the time constraints, I just want to say again, this Supreme Court opinion is on a lot of lips out there in Indian country, but nothing is really going to change immediately. It's an important time to do that coverage review, think about and manage your risks, train your employees, and absolutely certainly talk with your brokers and carriers. So thanks for the time, Mado, and back to you, Richard.
Thanks so much, Jeff. This is John Dossett. And Julian, if you go on to the next slide, we are going to talk to a number of tribal attorneys who have experience working on these issues. The first one I'll introduce is Howie Arnett. Howie Arnett is the tribal attorney for the Warm Springs Tribe of Oregon. He's represented the Warm Springs Tribe since the early 1980s and has a great deal of experience with issues like risk management and insurance contracts and these types of tort litigation issues. So Howie, thank you very much for joining us. I was just wondering your thoughts on the new decision.
Thanks, John. Well, when I read the decision, and just quickly describe Warm Springs, and one of my jobs, as John pointed out, is to advise the tribe's risk management office, and we've had a tribal tort claims ordinance that's modeled after the federal tort claims ordinance in place for about 30 years, and it covers the usual, range, just all tribal employees within the course and scope of their employment and with no limitations. And we have general liability coverage, and our exposure is capped at $100,000 per occurrence, or per event 300,000. So they're modest caps, and the coverage is based on those caps. When I read the opinion, I was thinking about differences between Warm Springs and Mohegan. One of them is a big one, which is the territorial and demographic difference. Warm Springs, pretty good sized reservation, 1,000 square miles. Majority of the probably 1,000 tribal employees are Indian. And almost all, though not quite all, of the claims that arise that invoke the tort claims ordinance end up in tribal court. And I assume that Williams versus Lee is still good law, and so if it's a tribal member or other Indian defendant in a tort claim that arises on the reservation, it's going to be in tribal court, has to be in tribal court. And I feel pretty good about the tribal court applying Warm Springs law, common law regarding the nature of the tort, and Warm Springs statutory law, the scope of the tribal tort claims ordinance. And maybe I'm wrong about that, but that's just was sort of my reaction. But it seems to me that there are some unanswered questions that hopefully I can find some answers to today or later on, and that is our exposure for tribal employees for claims that may end up in state court, off-reservation events, and tribal members, tribal employees who are not Indian. In particular, I was thinking about the tribal police department. Probably half of the 25 or 30 officers are non-Indian, and under recently passed Oregon state law, they're all authorized to enforce state law, state arrest authority. So they frequently are involved in events outside the reservation, responding to car accidents, interagency drug task force, and so on. There's some exposure for tribal police officers, personal exposure, and not covered by the tribe's tort claim ordinance. That would be a real difficulty. It's really hard to hire and keep tribal police officers, and to the extent they thought they had some personal exposure, that would make it even more difficult. And of course, we'd also be concerned about what this is going to do to our insurance premiums. So those are just some of my initial observations and some of my questions going forward that hopefully we can look for answers today.
Thanks so much, Howie. Really appreciate it. And Kane Smith and Anna Cole are with Drummond and Woodsum. They're in Maine, represent a number of tribes, and I think they've worked particularly on employment issues. Kane, are you with us?
Yes, John. Hi, how are you?
I'm great. Thanks so much for joining us.
Terrific. So we do a lot of work not only for Indian nations and their enterprises in the employment domain, but we also represent public sector employers generally. For example, we represent school districts, municipalities, and sometimes state agencies throughout New England. I have with me an associate, Anna Cole, who does a lot of our work both for tribal enterprises and Indian nations, as well as just general public sector employment counseling for our clients. And she has thought about these issues harder than I have, frankly. So I'm going to turn it over to her. If there are some specific Indian law questions that come up, I'd be delighted to address them, particularly the question of on-reservation torts, which I've been thinking about in this context because I think there's some very interesting tribal jurisdiction issues there and deference to tribal courts. But I'm going to let Anna speak directly to what we think are some of the important policy issues that flow out of the Clarke decision.
So good afternoon. So a lot of my comments are just consistent with the ones you've already heard. I agree with Mitchell that the court's opinion in this case really did come down pretty narrowly on the sovereign immunity issue, which is consistent with the way the court would handle a similar argument on behalf of a local or state government for one of its employees. And by treating the employees of Indian nations and their enterprises consistent with local government and state employees, it does open up some very strong arguments on personal immunity for tribal employees. What we've done, if you see on your screen, is just given you some definitions for some of the key components in this case. As Mitchell mentioned, the court addressed the fact that this lawsuit was not brought against the employee in his official capacity. An official capacity suit basically treats the employee as their position, not as a person, and therefore treats the lawsuit as brought against the employer themselves. If that had been the case, the court certainly seemed to indicate that the sovereign immunity may have succeeded, if not just been a very, very strong defense. This case was a personal capacity suit. They sued Mr. Clarke as just himself, and if they won, the judgment would be against him and his personal assets. That being the case, the three types of immunity, or the two immunities there that we gave you definitions for, are types of common law immunity that public and local employees may have access to. And the court, in footnote 2, left open the opportunity that Mr. Clarke could potentially establish one of these as a defense, or official immunity under Connecticut's law or under federal common law, as Mitchell mentioned. And I think in particular in this case, the strong argument is based on comity and utilizing Connecticut's own statute, where the court has said that the employee of a tribal nation should be treated like the employee of a neighboring state.
I think we sent out a advisory to our listserv of about 800 participants and got some useful feedback. But our general takeaway from this Supreme Court decision was that it was not a bombshell. If you look at the way that the suit was brought, I mean, it was strictly against Mr. Clarke in his personal capacity. It didn't suggest in any way that it implicated the tribe as a sovereign or the public fisc of the tribe, if you will. So it really just looked like a straight up action against him in his personal capacity. And under the common law generally across states, I mean, there's common law sovereign immunity that's developed by states. There's also the common law of federal Indian law. So sovereign immunity in that context is common law as well. And you sort of look at the common law of states with respect to sovereign immunity, and this was pretty much a no-brainer in terms of him acting in a personal capacity as opposed to something else.
Thanks a lot, Kane and Anna. Oh, I'm sorry, go ahead.
So the only thing I was going to say at the end is if tribes are looking for some takeaways, and I think it's certainly worth a discussion today on the webinar, is about adopting some of their own ordinances that are similar to the Tort Claims Act of the states that they're surrounded by, and that they expect their employees to be out and about in, especially the immunity provisions in those statutes. Because if you provide a certain type of immunity to your employees and have waived sovereign immunity in the tribal courts for those claims, so people who are injured can't sue your employees, but you're letting them sue you on your terms, it increases the chances that some kind of comity will be extended to the tribe by a neighboring state.
We understand that's a very intimate public policy choice for every individual tribe. Thanks a lot.
Thank you, Jane and Anna.
This is Richard, John. I just wanted to thank all the presenters up to this point in time. Again, providing their perspective, a quick overview with respect to the implications of Lewis v. Clarke. I know that we have Bryant Rogers coming up next, and he has several bullet points on his slide. I think this is a great opportunity to move towards the questions and the discussions following Brian's presentation. I think many in Indian country are familiar with Bryant Rogers. He argued successfully the Dollar General case before the Fifth Circuit, as I recall. And, we ended up with that 4-4 tie in Dollar General when it was argued before the U.S. Supreme Court following the death of Justice Scalia. So Bryant is well steeped in a number of these critical issues facing Indian country. So we're really happy that he could join us today. Bryant?
Thank you, Richard, John. So I'm not going to cover what's on my bullet points. They were a handout. They sort of speak for themselves, covered in questions if they're questions. I want to focus on somewhat of an elaboration of a couple of them. Now that tribal officials can clearly be sued in tort in their individual capacities, I envision suits like interference with contractual relations, like fraud in the inducement on contracts, and those things can be filed in the federal district court in diversity jurisdiction if you got an out-of-state plaintiff and a tribal official. Tribes are not persons under diversity, but tribal officials are. So I think this is going to be a concerning area. I think it's critical to try to salvage the notion that Lewis did not change the rules for own reservation torts in this regard. And to the extent that fails and we're looking at official immunity, I agree with all the prior speakers that there's a good chance, particularly the higher up the hierarchy you go in a tribal government, to get absolute immunity, official immunity, similar to the way federal employees have it, and certainly for tribal prosecutors, judges, and legislators. Not so clear to me that we're going to win those for van drivers for off-reservation torts using immunity. Maybe we will, and I'll be surprised. I'll be pleasantly surprised. But what's more concerning to me than the tort claims is something alluded to Arnett. When you've got tribal officers sued under 1983, mostly police officers, mostly cross-deputized officers, sometimes joint action cases when they're acting jointly with state police officers or county police officers, they're subject to liability. Evans v. McKay is an old case that confirms that under 1983. And, there probably was never sovereign immunity as a defense to a 1983 claim. There are certainly qualified immunity and variations on official immunity. So in that extent, it doesn't change. But I think it is going to be, we're going to see more of that. And Bivens cases too. We've got a number of tribes that have been sued and officials being sued under Bivens. You win them on the merits mostly, but if you have joint action with federal police officers, your tribal police officers are liable under Bivens. And again, you've got official immunity, qualified immunity, but not the absolute kind of those. But then the one that bothers me the most is 1981. And there's a number of cases around the country, 10th Circuit, 11th Circuit, where tribes and their officials have been sued under 1981. The tribes get dismissed out. The officials sometimes have to go to trial. We had a major case out of New Mexico. I think Richard Hughes is on the listening in. He handled it, and he did a great job of getting it dismissed on sovereign immunity grounds. But those were really individual capacity cases, claims against the tribal governor. He got a $347,000 jury trial verdict against him, and $1 million penalties on a lease dispute. That was dismissed on sovereign immunity grounds. Would it be dismissed today on sovereign immunity grounds? Would we win the official immunity? It's tough because when you're dealing with civil rights statutes, the cases are not great that you get absolute immunity even when you're a top executive. if you're accused of violating. In this case, the arguments are that the lease was terminated or the lessee was mistreated because he was white. And the tribe had to defend that. So it's a worrying area. And I want to mention one other point. Greg Smith at Hobbs Strauss did a really good sort of concerning article on the unrelenting assault of Morton v. Mancari and the attempts to roll back the notion that tribal and Indian treatment is a political, based on political status and not race, Indian preference, all that stuff. I can see more cases now attacking Morton through the guise of 1981 claims. In this case, while it might not actually, because it's more on torts, change the landscape, it's going to just invite more litigation. And so that's the major concern I have is not so much the tort claims as the Bivens 83 and 81 cases. So I'll stop with that.
Thank you very much, Bryant. That was really helpful. And I appreciate everyone's comments. I mean, I feel like I'm smarter already after listening to all of this discussion. Julian is helping us with the questions, and I think we're going to head into the questions and discussion time now. Julian, has anyone raised their hand or asked a question?
Yes, yes, we do have a few questions. Let's start with, let's see. Would any of the insurers recommend amending the liability policies to state that the insurer will defend and indemnify only pursuant to a Tribal Tort Claim Act?
I guess we go to Dina.
You know, I'd welcome a comment from Jeffrey there if he has a different thought, but I guess I'm not sure I understand the question. Amending it, like if your policy already requires defense and indemnity, amending it to only apply in certain situations would seem to be narrowing that. So I'm not sure that would be helpful to the tribe. It would seem to narrow the insurer's obligation.
Dina, this is Jeff. I heard the question the same way and have the same reaction. I mean, maybe if somebody can elaborate, or if you know, we can take a look at that and follow up somehow.
Maybe. Yeah, the questioner, if you can repeat your question if you want to clarify it, or you can raise your hand by pushing the button that says raise your hand, and then you can talk live and in person. So, Julian, are there any other questions?
Yes. If the tribal employee's conduct occurred on the tribe's reservation, would there have been a different result? Would the employee would have been able to be protected under the tribe's sovereign immunity?
Maybe I'll go to Jeff Blackwell on this one. I thought Jeff Blackwell had a good answer yesterday.
So there's only two sentences in this majority opinion that reference on reservation, and one would seem to think so. I mean, we all know where one of the concurring opinions ends up with respect to Bay Mills, but I guess we're going to learn. I guess we'll learn that in the future in meeting out. I really like some of the answers that have already been offered by some of the attorneys about strategies for defending that. But it would seem that the opinion, Sotomayor's opinion, would seem to suggest that, yes.
Any of the other panelists have an opinion on that. That seems to be one of the key questions right now. Is whether this only applies off reservation or whether it would also be brought on reservation.
This is Mitchell Reich. I think that I'm not sure there'd be a different result in terms of sovereign immunity as a defense. I think that the logic of the court's opinion was pretty clear that if you're suing an employee in his individual capacity, the state's the tribe's own immunity just isn't implicated. I'm not sure that would really vary depending on where the conduct took place. I think the stronger defense that you'd have if the conduct is on reservation is what other panels were alluding to, the kind of Williams v. Lee line of cases, that the state just doesn't have the regulatory authority to regulate the conduct that occurred on the tribe, on the reservation. And so I think there would be additional defenses there, but I don't know that I'd put it in the bucket of sovereign immunity.
This is Bryant. wanted to say that to the extent you're facing Bivens claims, 1983 claims, or 1981 claims, the on-reservation, off-reservation distinction clearly doesn't exist.
Right.
And that would be, this is Kane, that would be because there's a federal question and there'd be federal court jurisdiction in those settings, because the Bivens actions and the Section 1983 and 1981 are federal laws that would be invoked for federal court jurisdiction. But if you're talking about a common law tort, such as this, a personal injury arising on the reservation, and you have a state citizen suing a tribal employee for an accident occurring on the reservation, I believe that the line of authority stemming from Williams v. Lee, which was the same setting, only a common law contract violation, would render that lawsuit subject to the exclusive jurisdiction of the tribal court. And then the question would arise as to what's the nature of the sovereign immunity defense. And to me, that would be a question of the common law of the tribe to resolve. And it might be up to the tribal court to grapple with some of these issues of comity that might or might not be available.
So this is Jeff Black.
Go ahead, Jeff.
This is Jeff. I just wanted to clarify. Yeah, my reaction was to the jurisdictional elements, not the eventual outcome based on a suit in personal capacity.
Yeah, I think we're going to. This is Richard Guest. I think it is going to be a process over time where we're going to see a number of different cases brought both on and off reservation, and I think that most of the cases would be resolved along the Williams v. Lee line, that the state courts just simply don't have jurisdiction because it occurred on reservation. One thought that comes to my mind is, what if it's a non-Indian property owner on the reservation and the tort occurs on his property? And it's fee land, his property, tribal official or employee. How are the state courts going to look at that case? It's troubling because I don't know that we have a good answer yet. So it's going to depend on the particular facts of the case. There's no one right answer. I think, though, that as most folks have opined so far, is in most cases, the state courts simply are going to recognize they don't have jurisdiction.
Richard, let me just, one more thing, Bryant. A number of tribes have compact provisions where they agree to state court jurisdiction under IGRA for torts related to their casino operation. There is, and that sort of, to the extent that IGRA authorized that, it's a governing act of Congress that gets them around Williams v. Lee. But there is litigation challenging the scope of that waiver, that transfer authority. There's a case, and I think it's going to be argued next week in the 10th Circuit, prior rulings in the U.S. District Court here in New Mexico, that it's only for torts where it's necessary for the regulation of gaming. So tort claims about payouts and stuff, but not slip and falls and assaults in the parking lot and whatever. Split of authority, but it is if the challenge to that prevails, then Williams v. Lee would be reinvigorated as to those kinds of cases.
This is John. I thought I might throw out just one question and then go back to Julian to see if there's any other questions. But when I read the opinion, I guess one of the things that struck me was this idea of the real party in interest, that Justice Sotomayor seemed to have a fairly easy time distinguishing that the real party in interest here was not the tribe, it was the individual. And to me, it just didn't seem that clear. I wondered if you guys had any thoughts about that. Is the law on the real party in interest really as clear as Justice Sotomayor seemed to think it was? Well, maybe I'll get a Mitchell on that one.
Yeah.
Bryant?
No, go ahead, please.
Well, I was just going to say, I don't think it's that clear. And envision a situation where you had a contractual obligation to indemnify the group. It wasn't just in the statute. I think you could make a stronger case. I was very disappointed at the court's failure to acknowledge that this is largely in an area governed by law now, by statutory law, not common to federal, state, and foreign sovereign situations, and it's true for tribes too when they've adopted Tort Claims Act. So I thought that was a mistreatment and an insulting, basically, approach to the tribe's own law, and I hope that some pushback can happen later. I don't know if it can be overcome.
This is Mitchell. I'd just say two things about that. One is I think at oral arguments, most members of the court recognize that this question of whether the indemnification statute made the tribe the real party in interest was really an open question, and there was no clear authority on point. I think the opinion treated it as if it were an easier question than it seemed to most people, that just sort of this was a voluntary undertaking that didn't matter. But it really was an open question for this case. The second thing I'd say is, I think here, while the court may have seen it as easy, there will be other cases, I think, where the officer is named in his personal capacity as the defendant, but the state or the tribe could still be the real party in interest. There are cases that recognize states are the real party in interest in that case, even where they're seeking damages from the officer. There's a case, Edelman v. Jordan, that was at issue in the briefing here, where essentially someone was sued and asked to pay out benefits that the state owed the claimant. And so in that case, even though it's a damages suit against an officer, the money is really going to come out of the sovereign's own treasury. So in a case like that, and there's a lot of other ones you could think of where effectively someone's trying to compel the tribe to act in a certain way via through the route, the pleading maneuver of suing the officer. And those, I think, are absolutely still alive. There's a live argument that those are barred by sovereign immunity still.
One other thing that's probably worth mentioning is that in this case, the court's job was made a little bit easier because the determination of whether the indemnification would actually be triggered was not identical to the question about whether Clarke was liable for the accident. And because additional evidence would be needed to establish the tribe's obligation to pay out under its statute, it was easy for the court to say the tribe is not the real party in interest, because even if liability is found against Clarke, the tribe is not automatically paying the judgment.
Yeah, I remember that part.
John, I had a question. John,
go ahead.
I had a question for Mitchell as the SCOTUS practitioner, and Mitch, my understanding is you clerked for Justice Kagan, and when we look at the court in the opinion in Lewis v. Clarke, we see that Roberts chose Sotomayor to write the opinion, and it was a unanimous opinion, although there were two concurring opinions, the one by Ginsburg and the one by Thomas. Again, not surprising for either of them with respect to the basis on which they concur, but it was interesting to some of us that nobody joined with Thomas and nobody joined with Ginsburg on the concurring opinion. Do we read anything into any of that, or is that just standard practice at the court?
Well, I think that clearly those two are still keeping open the sort of Bay Mills dissent position that even if sovereign immunity were implicated by a suit like this, it wouldn't extend to off-reservation conduct. I'm not recalling. I remember Justice Scalia joined them in that position, and there must have been a fourth vote who's escaping me who didn't join them.
That was Alito.
Alito. So it is a little interesting that Alito didn't join either of those concurrences. It may be that may be a sign that he accepts Bay Mills as the law now and is no longer fighting that, or it could be a sign he just thought it was inappropriate in this case to kind of raise that issue since it really wasn't implicated. It's a little hard to guess, but it could be an encouraging sign in that respect.
Good, and the fact that Sotomayor, who in Indian country is held up as a tremendous advocate at the court for tribes, has written lone dissents in cases. Is that something, again, most of us are not familiar with exactly how opinions get assigned. Is that something that she has a say in, or is that something that Roberts just goes down the line and figures out? I know you're not in the conference room with them, but general practice.
It's hard to read the tea leaves on these things. I mean, the practice is Roberts does assign it on his own and doesn't really ask anyone's permission to do it. So she didn't have a say. On the other hand, she did write it really as narrowly as possible and to keep open that, I think it's quite clear she wanted to keep open the official immunity argument. And so he may have thought, and this is total speculation, it's very hard to know what, it could have just been, who the other opinions that month went to, that this was the one that, was made sense for Sotomayor. But it could also be that he wanted her to write a narrow opinion and knew that she would do it. And that if it had gone to someone who's more skeptical of tribal claims, they might have written something that was more aggressive and that would have lost votes like hers or others who are more sympathetic to tribes.
Interesting. So, Julian, let's go back to the questions from the audience. Do you have any more questions?
Yeah, I'm going to unmute Tom Murphy's line. He has a couple of questions. Tom, are you on the line?
Yes.
Go ahead.
Yeah, my question was to the insurance companies whether, it doesn't matter what the Mohegan Code says about indemnification, because liability policies almost always say we will defend and indemnify, for any judgment against an insured, and insured is an employee acting in the course and scope. My question is, would it be beneficial to amend insurance policies to say we will only defend and indemnify pursuant to a Tribal Tort Claims Act, put that in the policy so that the choice is you can either proceed under the Tribal Tort Claims Act or go against an uninsured employee?
So that would be helpful to us. It's similar to doing something like even sublimiting, an employee for those kinds of cases. The problem with that is that I don't know if in the long run the tribes are going to be comfortable with that. It would incentivize folks, but what happens if they continue to sue, if they continue to suit in state court? Now you've got an employee that is sort of hanging out there. And it's helpful in the sense that it makes it unattractive to plaintiffs, lawyers, but I'm not sure. I think we need to think through how, if the tribe is willing to do that and take that position and sort of, draw that line in the sand so plaintiffs' lawyers, realize that the tribes are not going to, cave. That's my sense of that. I think it would help, but I just don't know if it makes sense long term in terms of retaining employees or reputational risk, that kind of thing.
How about saying that in the policy that the insurer will defend any employee sued under Lewis v. Clarke, but will only indemnify if you proceed pursuant to a Tribal Tort Claims Act? Then the plaintiff's attorney would not only have to go, if they wanted to maintain the individual capacity suit, they're still going to have to face an insurer-funded defense, but there's no pot of gold at the end of the rainbow.
Correct. That might be something we should consider.
So,
Jeffrey, I don't know if you have any sort of reaction to that.
So I have sort of the same reaction. I think it's a very interesting question. I think it's certainly something to consider. I think it might be premature to answer, but I had sort of suggested something similar in my remarks, but I do think it might be a little premature to answer because it might have there might be the kind of unintended consequences associated with employment.
Yeah.
But I certainly appreciate the question. I just don't think ready to answer it conclusively right now.
I think it still would, this is Bryant, would be problematic for those employees. They have judgments against them unless they file for bankruptcy or they have nothing. They still got a judgment to deal with even if you've defended them and you lost. So I think it'd be very hard to keep tribal employee circumstance.
Absolutely. Yeah.
So, Julian, a great question, and thank you, Tom. Is there any follow-up from you, Tom? And then maybe we'll go see if there's other questions. Julian,
I didn't have any follow-up.
Okay, thank you. And Julian, do you have other questions? I wanted to remind folks that there's after we finish these questions, we're going to go on and discuss judicial vacancies and U.S. attorney vacancies. So go ahead, Julian.
There's a couple of questions in regards to jurisdictional issues and PL 280 states. So would that have any implications if it's dealing with the PL 280 state?
Well, you don't have Williams v. Lee as your fallback jurisdictional defense. That's the main implication.
Yeah.
So for those tribes that are subject to 280 jurisdiction for civil claims, all tribes in 280 states aren't.
Are there any other questions that jump out, Julian? At some point, there may be more questions than we can take here today. In which case, we're going to try to get back to you, and we really appreciate all your questions. Yeah, go ahead, Brian.
John.
Yes.
This is Jeff Blackwell. I just wanted to take just a couple of minutes to probe just a little bit on an item that had been mentioned earlier, the potential implications associated with certain suits being brought, potential implications associated with Morton v. Mancari. And the reason why I ask is, as a former regulator, I dealt with those sorts of challenges all the time as a former federal regulator, and I was surprised to see the awareness of that as sort of linchpin to so much in the treatment of tribes in the United States. So I was wondering if there was a little more to that thought about watching for and monitoring that potential type of development. And I apologize, I can't remember who made the remark.
That was Bryant, and I'll turn the question over to Bryant.
Particularly, and Greg Smith and Carolyn Mayhew did a great article on this, and basically what's happening is the coterie of lawyers that are consistently and persistently arguing that Indian law is race-based, and they're trying to unwind the whole special status of tribes on that basis. And their article, Apocalypse Now, The Unrelenting Assault on Morton v. Mancari, was in the Federal Lawyer, April 2013. But even up through then, there's 5 or 6 cases they go through where this argument is being made. I think it will keep being made, and I just think that while there can be 1981 cases that don't involve that at all, where the contractor says you mistreated me because I was white, you don't have to go there. But I'm just afraid it's going to be a new way of trying to reopen that can.
So I spoke with. Go ahead. Sorry.
Well, I was just going to say that just to sort of drill down on that, I think that where the reason that arises is in the context of tribes giving preference to their tribal members over others in contracting. That would be the example of a Section 1981 action, which is an action that's brought against a defendant that is discriminating on the basis of race in a contract. So the notion would be that, well, actually, that distinction isn't a political distinction under Morton v. Mancari. It's a race distinction, and that's where we have to worry about these challenges to Morton v. Mancari, which said that these kinds of discriminatory, quote-unquote, choices aren't really race-based. They're because of political affiliation. I think that's getting pretty esoteric for the risks that we face. I think looking at this whole Lewis v. Clarke case from Mile High, what it does is it challenges us to think creatively in representing Indian nations as sovereign entities, as governments. What is good public policy? And it reminds me of the concerns that have been generated around civil rights generally, because, of course, you know, Title VII excludes Indian tribes. And so there are a lot of remedies that one might look at from the outside in, like providing a remedy for someone who faces sexual harassment in the workplace that you can't get unless a tribe enacts its own law to provide that remedy. And from a fundamental fairness perspective, a good argument could be made that tribes should provide those sorts of remedies within their own forums in accordance with their own public policies. And if they don't, you know, it appears like there's kind of a gap for employees that might be subject to that kind of horrible treatment. So these things make us think harder about what is good public policy for tribes and what is fair. What is fair for a tribal employee to not be hanging out there and facing a big tort judgment? What's fair in terms of waivers of sovereign immunity? We do a lot of hand-wringing about waiving sovereign immunity. And we all worried about it in the Bay Mills case, you know, thinking that we should get rid of that case. It's bad facts, but we sort of pulled it out. And then there's the whole, you know, the distinction between the application of a law and the ability to enforce it, which was the Oklahoma Tax Commission versus Citizen Band Potawatomi. And we saw that case going up from Madison County involving Oneida Nation, and the Oneida Nation decided to waive its sovereign immunity so that we didn't have to face that in the Supreme Court. I'm just saying that, you know, this is a process of government being good governments for tribes, and thinking hard about where the rubber meets the road and learning from the lessons of each other and also governments such as states. Not that there's any reason to mimic states, but it's just a broad perspective.
Kane, thank you very much. I think that leads nicely into, as we begin to wrap up this part of the webinar, the fact that for the Supreme Court project, and this is Richard Gessett, NARF DC, for the Supreme Court project, what we're planning to do is to monitor, as we do with a number of different subject matter areas, including sovereign immunity, the cases in the lower courts, with special attention to those that are implicating Lewis v. Clarke, and to begin tracking those. And then if over time we start seeing a trend that may be of concern, maybe at that point, you know, if there are concerns that are coming up, creating a work group to, you know, within a sub-work group within the project to begin to discuss how do we address those new developments. It's just really hard to say today what the cases are going to look like. There are a lot of creative plaintiffs' attorneys out there. You know, we've already seen Kuhnauer out in Washington rule on the disenrollment and the ability of that suit on behalf of the disenrollees to go forward against the tribal officials, because sovereign immunity is not implicated if they're sued in their, if the tribal officials were sued in their individual capacity. So we want to monitor those going forward. I don't think we want to form a work group yet, but there may be future discussions just like this, more in a conference call format. Also, as a part of this call, I wanted to take an opportunity. I don't know how many folks are still on the call, but to let the members of the Tribal Supreme Court Project know, those who haven't heard, is that I'm leaving NARF this summer. And so the work of the Tribal Supreme Court Project will move forward with Joel Williams here in the NARF DC office taking primary responsibility as the lead attorney for NARF. So I'm not going to be here in Washington, D.C., moving with my family out to California, as far away from Washington, D.C. as I can possibly get now with the recent changes here. So just wanted to take that opportunity to say thank you to everyone. It's been a tremendous gift to me. Never imagined that I'd get to do this type of work at this level with so many great attorneys, you know, working on behalf of the tribal leadership and having a great partner in John Dossett and NCAI in doing the work that the tribal leaders set out for us back in 2001. So I wanted to just say, let folks know that.
Say, Richard, this is John. I just wanted to say thank you to you and all the amazing work that you've done on behalf of the tribes with the Tribal Supreme Court Project for the Native American Rights Fund. We're going to miss you a lot, but I think also we'll probably be working with you again very soon. It'll be sooner than we think. So it's just see you down the road. And then if you go to the next slide, I wanted to introduce Joel Williams. Joel is going to take Richard's place. Many of you may know Joel. Joel works in the Native American Rights Fund in the D.C. office. So we're really looking forward to working with Joel. And we wanted to turn right to the next project that we're going to start working on with Joel, which is the judicial nominations and U.S. attorneys. Say hello, Joel. Are you there?
Yeah, sorry, I had to unmute. Thanks a lot, John. And hello, everybody. I've been working with Richard on the project now since I came on at NARF about 4.5 years ago, and a lot of behind-the-scenes work on the project. So I'm really looking forward to working more closely with all the attorneys and with the folks over at NCAI. So thank you.
Thanks so much, Joel. If you go to the next slide. We'll cover this pretty quickly. We've got about 15 minutes, but we wanted to get to, there's another really important issue out there that's going on right now, and that is the huge number of vacancies that exist for United States attorneys and judicial vacancies. And this administration is going to be making nominations very soon, but there's a lot you can do to influence that. All 93 U.S. attorney seats are open. As you guys know, in Indian country, the U.S. attorney plays an extremely important role. They prosecute all the crimes, on non-PL 280 reservations. They do a lot of work to protect tribal natural resources and other issues on the reservation. I just wanted to review with you very quickly that this process of U.S. attorneys is really controlled by your Senate offices. The president doesn't choose all 93 of these U.S. attorneys. Whoever is the senior Republican senator, the same party as the president, will usually make a recommendation, sometimes of several names, and then the White House usually goes along with the senator. This is an old tradition in the Senate. If there is no Republican senator, the same party as the president, they'll often talk to the most senior Republican in the House of Representatives. So that's where you know who to go talk to. You can find out who the candidates are. You can make recommendations if you have somebody you really like. It's also important just to get involved if they're usually considering half a dozen different candidates, and there may be somebody that you really don't like, you've had bad experiences with in the past. So that vetting process is really important. Now is a good time to be talking to your United States Senate offices, or in some cases it'll be the senior Republican in the House. Did you have anything to add to that, Joel?
No, I think that covers it very well, John. Thank you.
Thanks. The next slide, if you go to it, is talk about judicial vacancies a little bit. I think we missed a slide here, but there's like 129 vacancies across the country. About 20 of them are in the circuit courts, and another 100 or so are in the federal district courts. These seats are incredibly important to the law in your area, particularly the circuit courts. And then we're going to review very quickly. There you go. If you go into the next slide, we'll go back to the Ninth Circuit. I wanted to, in the Ninth Circuit, and this is, I think, 400 Indian tribes in the Ninth Circuit. A lot of tribal cases get decided out of the Ninth Circuit. There are 4 seats right now. One of them is out of Oregon. Each circuit seat is generally assigned to the senators from a particular state. So one of them is pending in Oregon, one in Arizona, one in California. And so tribes can have an influence in the exact same way by talking to your Senate office. There's one in Alaska. There's 2 vacancies in Arizona. These are for district courts. There's 6 in California. There's vacancies in Idaho, Nevada, a district court vacancy in Oregon, and another one in the three vacancies in the Western District of Washington. So there are an incredible number of vacancies just in the Ninth Circuit alone, and these are judges who are going to be making decisions about Indian law. If you go to the 10th Circuit, there's also a number of vacancies there. The Colorado seat is the result of Judge Gorsuch going up to the Supreme Court. And as those of you who followed the Judge Gorsuch nomination and confirmation, you saw that he had decided 60 cases that had involved Indian tribes, and about 18 of them he had written opinions. So you can see that a 10th Circuit judge, I think there's 73 tribes in the 10th Circuit. There's 2 vacancies in the Circuit Court and a Colorado vacancy, 2 in Kansas, 3 in the Western District of Oklahoma, and 1 in Utah. So you can see there's a lot of vacancies here. If you go into the next slide, I think we have the 8th Circuit, North Dakota, Minnesota, also 2 district court seats in Minnesota. And we go to the next slide, we listed out quite a few more vacancies in various districts around the country that have Indian tribes in them. Wisconsin, Indiana, Michigan, Rhode Island, Connecticut, Massachusetts. I'd encourage you, all of you, to take a look. If you just put in judicial vacancies into Google, you'll get the United States government list that's on I think it's the U.S. Courts website. Just look at your district and see whether or not you have a vacancy. If you go to the next slide, the process is fairly simple. The senior Republican, or the senator who is the same party as the president, will usually make recommendations about who is potential judicial nominees. Sometimes they have a small commission or a board in their state that helps them make those recommendations. Sometimes they may make several recommendations. I think particularly for circuit court seats, those are more political. There's more White House involvement. There'll be several recommendations under consideration. You can have an influence on that process by communicating with your Senate office, asking them who the candidates are, all very important to do to be involved. If there is no senior Republican, then you work with a senior Republican in the House. It's very important to inquire about the candidates and kind of vet them. I'll use the example from 2007 when there was a guy, his name was Myers. He was William Myers. He had been the former Solicitor of Interior, and tribes did not like him very much because of the positions that he took on legal issues involving tribes. So a number of tribes opposed he had been nominated by President Bush. Tribes opposed it, and that helped. He never was confirmed. So tribes can have an influence on this. It's better to do it earlier and talk to your Senate offices, but it's both to support good candidates, but occasionally there are candidates who are really, they're not good on tribal issues, and you very much may want to speak out and oppose them if that is the case. Joel, is there anything else, or maybe there's questions or comments on judicial nominees and U.S. Attorney nominees?
Sure. Thanks a lot, John. I think that was an excellent overview. Couple things that I would add here. One is NARP and NCAI have been working along with the National Native American Bar Association on this project on the judiciary, going all the way back, same genesis as the Tribal Supreme Court project back in 2001. So it's certainly been a priority for a long time. And our focus is getting good, qualified Native candidates on the federal bench, in the U.S. Attorney's offices, Native Americans, and also, other folks that understand and appreciate tribal sovereignty and the issues that Indian tribes have to deal with. So, and along those lines, when we're at a time like this, where there are so many vacancies, we're at the beginning of administration, it's a good opportunity for us to identify qualified attorneys that can be nominees for this position, for these types of positions. And John went through where we have, a lot of vacancies out there in Indian country. That's not all of them, and we really need help out there on the ground. The people on this call are the people that work with the qualified attorneys every day that they would make great federal judges, great U.S. attorneys, and we need to know who those people are. We know a lot of them, but not all of them. So that would be my first ask is if you know somebody that's a Republican, a good qualified attorney for one of these positions, let us know. Give us their name. You can get in touch with John or myself, and we would love to hear who they are. So that's number one, and then the other is please stay tuned as we move forward with our work. We'll be communicating with this group and with the folks on the Tribal Supreme Court Project list to engage on this work of the Judicial Selection Project.
Thanks so much, Joel. Hey, Julian, and I wanted to mention Julian Nava, by the way, is a staff attorney with NCAI. He's also working on all of these issues, so please feel free to communicate with Julian as well. Julian, are there any other questions about, that have come up, or maybe somebody has their hands raised?
Yes, there's one question. Let me unmute. Wes, are you on? Wes Williams?
Hello.
Yeah. Wes, are you on? Well, I guess he got off.
Well, no luck.
Yeah.
All right.
I think
any other questions, or if not, I'm probably gonna wrap it up by turning it over to Richard Guest. This may be our last webinar with Richard.
Thanks, John. No, I just do appreciate pulling this together. I think folks with the Supreme Court Project are aware that the court has granted cert in the Patchak case. So stay tuned. We're talking with the attorneys, have a small call scheduled next week with them. We'll go out to a larger call with the Supreme Court Project in due course. A bit of time, the tribe and the United States are respondents in that case. And some other interesting cases, it looks like, although things are not as busy at the Supreme Court at present, you can anticipate a number of cert petitions getting filed in cases where tribes have prevailed in the lower courts. And we also have significant activity in the lower courts, at the courts of appeal level. If you've seen any of our emails with respect to those cases and have interest, please do continue to participate. If you're not on the work group for the Supreme Court Project and called into the webinar and now have an interest in joining, you can still send your contact information. I'm still keeping that. I'm not leaving till the end of June. So I will continue to be here supporting Joel as he transitions into my seat, literally. And so send me your contact information, just richardg@narc.org, and I will add you to the project work group list, the distribution list. Okay, that's it, John. Thanks again to everybody.
Thanks so much to everyone. Thank you, Julian, for being the webinar master. We really appreciate it, and we'll be talking to you soon. Thanks very much.